Are there any other votes? Announce the results.
Ayes 84, noes 33.
The bill is passed. Mr. Morelli.
Yes, thank you, sir. If we could take Rules Report 535 on page 7 of the A calendar by Ms. Fahey.
Senate 8114, Rules Report Number 535. Committee on Rules, an act to amend the county law.
Read the last section.
This act shall take effect April 1st, 2017.
Clerk will record the vote. Ms. Fahey to explain her vote.
Thank you, Mr. Speaker. I just want to thank you. I just want to make note. We passed this bill a couple of weeks ago. This is a slightly different draft as we were in negotiations with Senator DeFrancisco, and I want to thank him. It's been a truly bipartisan effort over the last year and a half, although in some ways over the last 50 years. It's a momentous occasion, and in many ways this bill is 50 years in the making. What this will do is provide for a full phase-in of state funding over the next 7 years, oversight and standards for indigent legal services by reimbursing the counties for these services, and those are counties throughout New York State. In a landmark decision 50 years ago of Gideon versus Wainwright, the Supreme Court ruled that it is a fundamental right that those who are accused of a criminal offense have a right to legal counsel, whether or not they have the ability to afford it. However, in New York State, 50 years ago and since then, that constitutional right, that constitutional right was a cost passed on to the counties, which resulted in a tremendous expense to the tune of hundreds of millions of dollars, as well as very uneven services depending upon what county you lived in. This marks a new chapter with passage of this bill, marks a new chapter in moving forward in New York to fully realize the funding and to address this constitutional right, and addressing what Judge Judith Kaye called in 2006 when she issued a report on this, an ongoing crisis in public defense. Countless people have been involved in this, and I want to start by thanking Chairman Lenthal, Chairman Weinstein for their support, as well as all the code staff, along with Albany County, Dan McCoy, and former Judge Larry Rosen, who brought this to my attention, and countless other groups who have worked to bring this bill to us. Again, some have worked on this for 10 years and more, including NYCLU, the New York Civil Liberties, Chief Defenders, the Defenders Association, Albany County I mentioned, the State Bar Association, Association of Counties, the ILS office, and the governor for settling a similar case on this for 5 counties 2 years ago, which set up this bill. And I vote in the affirmative, and thank you, Mr. Speaker.
Ms. Fahey in the affirmative. Mr. Lenthal.
Thank you, Mr. Speaker. Believe it or not, ladies and gentlemen, this is a monumental moment in this House because of Ms. Fahey. We can now have Democrats and Republicans alike supporting legal services for the poor. And the reason is that the Constitution requires it, first of all, but more importantly, now we have a vehicle to pay for it and take the burden off the counties of our state by requiring that the state of New York pick up the expenditures for legal services, which they should have done in the first place. But now it will be the law of the state of New York. Thanks again to Ms. Fahey and to Ms. Weinstein and to all the others that have fought in this House for this to happen. And it took the Speaker of the Assembly to make sure that this would happen by allowing this bill to come forward today. And we thank the Speaker tremendously for his support. He understands the need and did it. And here we are today. And as I said at the beginning, history will mark down this day because we will all remember it for legal services being provided for everyone, regardless of their ability to pay. I vote in the affirmative.
Mr. Lentol in the affirmative. Mr. Perry.
Thank you, Mr. Speaker, for an opportunity to explain my vote. I think that tremendous amount of thanks is due to our Speaker for his strength and skill in negotiating to bring us to this point where we can vote on what is a landmark piece of legislation. I'm sure that all of us voting for this bill tonight are proud to support it. And this legislation was a very top priority for the Black, Puerto Rican, Hispanic, and Haitian Legislative Caucus. This is because study after study has shown in our state that arrest, prosecution, and incarceration disproportionately impact African American and Latino adults and children. It hurt our families. Oftentimes when people have to try to put aside bills that they have to pay to scrounge up some money to try to find legal representation. A very famous attorney once said that you're sometimes in America you're innocent until proven poor. This is a big way to resolve that and make it untrue in New York State. I urge the governor to sign this. I also thank our colleagues who worked with us in the other house. We stand proud tonight, Mr. Speaker. I withdraw my request and vote yes. Thank you.
Mr. Perry in the affirmative. Ms. Weinstein.
Mr. Speaker, to explain my vote, I first want to commend the sponsor of this legislation for her diligence, her steadfastness in trying to provide equity for defendants, for counties around the state. When we first made some major changes in indigent legal services, probably at least a dozen years ago, we put together a fund. And unfortunately, over the years, sometimes the Indigent Defense Legal Services Fund has been swept for other purposes. And it's always been a shame that we didn't earlier try and dedicate more, or weren't successful. We tried, but we're not successful in dedicating more funding for indigent legal services. I'm so happy that the Senate sponsor, Senator DeFrancisco, who was chair when the Senate Judiciary Committee while I was chair, and who over the years had shared the concern for the counties to make sure that they had the funding to provide indigent legal services, has joined with this effort, and I really look forward to better representation for individuals accused of crimes throughout our state. We've already provided some caps, case caps in New York City. This funding will allow case caps upstate so that defendants could get the full representation, defense representation they're entitled to. Thank you, Mr. Speaker. I vote in the affirmative.
Ms. Weinstein in the affirmative.
Are there any other votes? The bill is passed. Mr. Morelli.
Thank you, Mr. Speaker. If I could give you the next two bills I'd like to take up in this order. Rules Report 290 on page 10 of the main calendar by Mr. Magnarelli, followed by calendar number 668 on page 62 by Mr. Kavanaugh.
Assembly 9490, Rules Report 290. Mr. Magnarelli, an act to amend the general municipal law.
Sub. It's a sub. So a motion by Mr. Magnarelli.
On a motion by Mr. Magnarelli,
The Senate bill is before the House.
the Senate bill is before the House, and the Senate bill is advanced.
Explanation and request.
And an explanation has been requested.
Mr. Chairman, this legislation will not allow industrial development agencies to exempt the 1/4 point of the mortgage recording tax that is allocated to New York State transit authorities.
Mr. Magnarelli, I don't mean to interrupt you, although you may
Mr.
have finished.
Speaker.
But can we have some quiet in the chamber so that we can each hear what we're saying? Thank you. Mr. McKevitt.
Please.
Sure.
The sponsor yields.
Just to clarify the process, what happens here, when an industrial development agency goes into a deal with a developer, my understanding is that when they go and they enter into an agreement, technically, when property is acquired, let's say to build a manufacturing facility or some sort of other type of project, the title of the property actually goes in the name of the industrial development agency, not in the name of the private developer. Is that correct? Is that how that part of the process works?
I believe so.
And because of that, because technically a municipal agency now has title of the property, they would be exempt from number of taxes which a private party would ordinarily pay. Would that also be correct?
Correct.
Correct. So what happens in this instance is when an IDA gets involved in the project and they go and they purchase the property, there would be certain exemptions. For example, when there are materials to be purchased for the construction of something, the sales tax exempt. What happens in this instance is that the mortgage recording tax becomes exempt because technically title is acquired by the IDA. Is that also correct?
Yes.
So what that happens, though, is that when the title goes there to the IDA and the mortgage recording tax is exempt, these authorities would be anticipating they would get certain monies each year in order to develop their operations. They get monies not only from the operations of doing the transit to the railway, but they depend upon the fact that they get mortgage recording tax. And by the IDA then acquiring title, it's depriving revenue which the IDA would ordinarily be anticipating. Would that be the case?
Yes, but let me add that it's a very small amount of money that we're dealing with, but it's a big amount of money to the transit companies that we are trying to keep going in upstate New York. So that's the real reason here. If we had to choose between the two, I think we have to choose the transit companies.
Thank you very much.
Thank you.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Mr. Ryan to explain his vote.
Thank you, Mr. Speaker. To explain my vote, I applaud Mr. Magnarelli for his concentration on the industrial development agencies. We often like to think of the industrial development agencies actually helping to subsidize manufacturing, but as we've seen all across New York State, industrial development agencies spend more time subsidizing retail outlets, malls, car dealerships, pizzerias, and while they're doing that, they're depriving our transit authorities of much needed money. So every year we come up here to fight for more funding for our transit authority, only if it have the IDAs that are scattered throughout New York State essentially waive that money and give it away. So we're filling up the bucket of water, and they're emptying it. So I withdraw my request, and I vote in the affirmative.
Mr. Ryan in the affirmative. Thank you, Mr. Ryan. All right. Are there any other votes? Announce the results.
Ayes 96, noes 0.
The bill is passed.
Assembly 6054A, Calendar 668. Mr. Kavanaugh, an act to amend the Administrative Code of the City of New York.
Read the last section.
This act shall take effect.
Explanation has been called for.
Thank you, Mr. Speaker. This bill would reform the major capital improvement provisions of the rent stabilization laws in New York by restricting the amount of the MCI charges that can be recovered from tenants to the actual amount spent, and by amortizing them over at a rate of 6% per year.
Mr. Fitzpatrick.
Thank you, Mr. Speaker. Would the sponsor yield?
Yes, Mr. Speaker.
The sponsor yields.
Thank you. Mr. Kavanaugh, this is a bill formally carried by Mr. O'Donnell, and far as you know, as far as we know, nothing has changed in terms of our debate on this. Historically, the major capital improvements follow the IRS code, allowing them to be factored into the base rent. An 8-year period for buildings with 35 or fewer units, 9 years for 36 units or more. Is that 6% also, will that apply outside New York City or just inside? Because it's 15% outside New York City.
It applies to the rate at which landlords under the various rent stabilization laws are recouping MCI benefits. It obviously does not apply to some of the tax provisions, the Internal Revenue Code sets, which are federal, and it doesn't apply to non-rent regulated housing. But yes, it's intended to apply to anywhere where MCI provisions are part of a rent stabilization lease.
Now, in the legislation, you want to limit this to the rent increase for an MCI to an enhancement or an upgrade. So would that eliminate repair of an elevator? If you have to replace an elevator or a new roof, would that be now disqualified?
No,
even though they're depreciable under the IRS code?
Those are traditionally considered major capital improvements, and they would be considered as such. We have had instances where landlords have tried to tack on improvements in projects that are not perceived as major capital improvements. This will have the HCR, the state agency, reviewing those, and again making sure that the charges that are being made are for the major capital improvements. I would note that in the current system, since the amount that they spent is recouped many times over, there's a lot of incentive to do improvements, to spend money on capital projects that a landlord might not otherwise spend. So we think there might be less incentive to do that. But yes, replacing roofs and elevators and all that, the law is carefully written. This proposal is carefully written to ensure that landlords continue to do that, because obviously that's important.
But that's a judgment made by DHCR as to whether it qualifies as an MCI, correct?
Yeah, the law does already talk about roofs and other things specifically. This law would not create the ability for HCR to decide that a new roof is not a major capital improvement. It might be able to review it and see that the contractor did a roof and also did some painting of apartments while they were there, or some landscaping or something, and say that those are not included in the major capital improvement.
And that would not change. The DHCR would still make that call, even though the landlord may try or attempt to get that covered by the MCI, but DHCR could easily reject that, correct?
That's correct. The purpose of this is to ensure that the spending for MCIs, for actual major capital improvements, are covered under the major capital improvement charge, and not things that are not major capital improvements. I was just saying it will not allow HCR the discretion to define what an MCI is from scratch.
Very good. Thank you, Brian. Mr. Speaker, on the bill.
Mr. Fitzpatrick on the bill.
Yeah, I would urge a no vote on this. There really is no need, in our view, to reform this statute. It has worked fairly. DHCR has, I think, worked very well in determining what is and what is not a major capital improvement. The 6% figure that is factored into the base rent is not unfair. And there was, we do use the IRS to determine what is depreciable to qualify for this. And there have been a couple of court cases that have affirmed the ability of an MCI improvement to be factored into the base rent. One dates back to 1989 in Ansonia Residents Association versus the New York State Division of Housing and Community Renewal. The court had ruled that the owner is entitled to a major capital improvement rent increase, and it stated, and I quote, "Unlike payments on a mortgage, A rent increase on the basis of a major capital improvement does not represent payment of a finite debt which the tenant owes to the owner, but rather is a payment for a service which the tenant continues to receive. A service which the tenant continues to receive after the owner has recouped the initial cost of the improvement. And in rejecting the tenant's argument, the court further noted that, quote, under the contrary construction of the statute urged by the tenants, owners would have little incentive to invest in major capital improvements if they could only recover the cost of their investment, and in fact might incur additional expenses in maintaining such an improvement after its initial cost had been recovered. New roofs and new elevators sometimes and often do need further maintenance and indeed repair. So, and the Court of Appeals in 1994 under the Bryant Avenue Tenants Association versus Koch, that decision was upheld. So I think it is clear that the system is not broken. We don't need to fix it. We don't need to move the goalposts, as we so often do when it comes to housing legislation. I would urge a no vote, and let's leave it the way it is because it's working just fine.
Thank you, Mr. Fitzpatrick. Read the last section.
This act shall take effect immediately.
The clerk will record the vote.
Mr. Kavanaugh to explain his vote.
Thank you, Mr. Speaker. Just while the votes are being tallied, I know the hour is late. I just wanted to, this is an issue that's very important in my district. I just want to thank all of you for the indulgence of doing it at this late hour. And I also wanted to thank, it was mentioned by my colleague across the aisle, but Danny O'Donnell and I have both worked very hard on this issue. And this bill is a merger of two MCI bills, but he and I both have been working hard on it. And for all of you, I think you know that, one MCI bill is probably better than two at this point. But I want to thank Mr. O'Donnell for all his work on this as well.
Mr. Kavanaugh in the affirmative.